Good morning, Council.
Morning.
This is our first case on the docket. Today is the Kansas Insurance Commissioner versus Trademark Incorporated and Doroteo Ballin and Ballin Company, LLC. This is an appeal from Sedgwick County. Council, I would ask that you enter your appearance for the appellant.
Your Honor, Brian Van Orsby for the appellant and cross appellee Trademark Inc.
John Nodgard on behalf of the Kansas Workers' Comp, the Kansas Insurance Commissioner, appellee and cross appellant.
All right. Thank you, counsel. I must say that we have an appeal and a cross appeal today in this particular case. Our panel is Judge Bruns. I don't know how he appears on your screen. He is to my left, as I see him, and then Judge Schroeder to my right. And we have certainly read your briefs, and we have received a pre-hearing memo from our research staff concerning this case. So we're familiar with the issues that you've framed in this very interesting appeal. Since there is a cross appeal, I would ask that the appellant, if you would briefly mention your position concerning the cross appeal before you conclude your initial remarks. I would certainly appreciate that. And then, Mr. Nodgard, when in your reply, if you would then just make your transition over into your cross appeal, we would appreciate that as well. Counsel for the appellant, do you wish to reserve any time for rebuttal?
Yes, Your Honor, the appellant would like to reserve 5 minutes for rebuttal.
Certainly. We'll do that for you. All right, so with that in mind, unless there's anything else to address, we'll begin. Let's hear from counsel for Trademark, I think. Proceed.
Yeah. Thank you, Your Honor. May it please the court. Good morning, Your Honor. Again, my name is Brian Van Orsby. Thank you for the opportunity to appear before you here virtually and provide an argument in this matter. It's my pleasure to represent the appellant cross appellee Trademark Inc. The facts in this case aren't particularly complicated or in dispute. That makes this case for this an interesting matter for purposes of statutory interpretation, but I thought it might be helpful to provide just some quick overview of the facts of this case. Trademark Inc. is a family-owned business here in Wichita, Kansas, that builds and designs homes. Quite common for the trade is to hire subcontractors for certain aspects of the building process, and that's what happened here. Trademark hired or entered into a subcontract agreement with an individual named Doroteo Ballin to provide some subcontracting services. As part of that agreement, Mr. Ballin represented that he had procured workers' compensation insurance for his employees if he was to use any on a trademark job. Unfortunately, that turned out to be untrue. On December 23rd, 2016, one of Mr. Ballin's employees, Juan Medina, was injured when he fell off a ladder. At that point, Mr. Medina served timely notice, written notice on Mr. Ballin for compensation, and then initiated a worker compensation proceeding against Mr. Ballin. During that proceeding, Administrative Law Judge Thomas Klein entered findings that Mr. Ballin was both uninsured and insolvent.
Now, let me stop you right there if I could, counsel. Uh, it, am I correct in saying that at that point, is there any procedure available to the injured worker to then proceed against the contractor, which in this case would be Trademark?
Your Honor, yes, the injured worker always has that option under KSA 44503. He or she can't proceed against both the employer and the principal at the same time, but at that point, there is still an option. And that's part of what's at issue here today. Something that was discussed in the Workers' Compensation Fund versus Silicon Distributing Inc. case is what they call the option analysis. The worker has the option to proceed against the principal, or as is the case in this matter, to implead the fund. And that's how we got to the fund being involved in this case.
And as I understand the facts, Trademark is insured.
That's correct, Your Honor.
And so later on, when we talk about an uninsured employer, that would not be Trademark because they were insured.
Yes, Your Honor. So the fund filed an action against Trademark in Sedgwick County District Court under KSA 44532A subsection B, which is the statute that we're discussing today, and that's at issue today. So I think the best place to start is the text of the statute at issue, because that's in interpreting statutes, we look at the plain language. So KSA 44532A, which is titled Liability of Workers' Compensation Fund for Uninsured or Insufficiently Insured Insolvent Employers and Cause of Action Against Such Employers. The provision under which the fund has brought this claim against Trademark is subsection B. Language states, Commissioner of Insurance acting as administrator of the Workers' Compensation Fund shall have a cause of action against the employer for recovery of any amounts paid from the Workers' Compensation Fund pursuant to this section.
Now, you're not arguing, are you, counsel, that the injured worker had to proceed against Trademark before they could proceed against the fund?
No, Your Honor, we are not arguing that. Again, that's part of what Silicon Distributing Inc. lays out, is that the worker has an option. They can proceed against the principal, Trademark, or they can implead the fund for payment. And in this case, Mr. Medina chose to implead the fund through his attorney, chose to implead the fund for payment of compensation benefits.
Would you agree with me that the whole point of workers' compensation, or one of the major points of the policy of workers' compensation, is to have these benefits paid as promptly as possible to the injured worker?
I would agree with that statement, Your Honor, and that's part of the reasoning why the courts found that there is an option for the injured worker. Because what was being argued in Silicon Distributing Inc. by the fund was that an injured worker has to exhaust all remedies before impleading the fund. And the court found that that's not the case because of precisely that purpose, that the purpose is to have the worker paid promptly. And the worker is free to decide how he or she wants to go about doing that.
And I know in your brief, you're taking issue with some of the statements in that Silicon case, and you're saying that it's dicta.
Yes, Your Honor.
And we should ignore it. Is that correct?
Yes, Your Honor. And just to discuss what Silicon Distributing Inc. really is, the fund appealed a decision holding it liable for payments of benefits, arguing in that case that a worker has to exhaust remedies. So what the fund was arguing in that case, and the issue before the court, was whether or not an injured worker has to proceed against a principal if there's one available prior to impleting the fund. And the court said, no, that's not the case. But along the way, there's a statement, and that's the statement that's at issue in this case, that the court made, where it said, if the fund pays on a claim, it may assert a KSA 44532A subsection B cause of action against either the insolvent or unlocated employer or solvent statutory employer, which is a principal, or both. And that's the statement that we take issue with, because that wasn't an issue before the court. There was no cause of action made by the fund. Rather, there.
Counsel, seems to me that there's dicta and then there's dicta.
Mhm.
And sometimes we refer to obiter dicta, which are statements that are made in passing, that are interesting and can be persuasive, but are non-binding. And then there is dicta, which are statements by an authority, such as our Supreme Court, that have meaning and are more than persuasive. They may not be binding, but they certainly point in a certain direction. Which is this in your view?
Your Honor, I believe the statement's made in passing, but even if Your Honor thought, this is the Supreme Court telling us how it might rule on this issue, I don't believe that's the case now, because of the Supreme Court's current statutory interpretation jurisprudence regarding statutes in the Workers' Compensation Act. There's several cases that we cited in our brief where the Supreme Court in recent years have overturned previous decisions interpreting statutes under the Workers' Compensation Act, because there has been a focus on interpreting statutes as to their plain language. But that's not what happened in Silicon Distributing, Inc. In fact, the court in that case began its analysis with a statement that I believe is pretty telling regarding how it interpreted the statutes. And there it said, in determining legislative intent, we are not bound or limited to consideration of the language used in the statute. And that's clearly contrary to the Supreme Court's jurisprudence now regarding how to interpret Workers' Compensation Act statutes.
Counsel,
Go ahead.
Let's talk about Silicon, though. It was a 1991 case, if I recall correctly. Is that true?
1999.
1999.
Yes, Your Honor.
This has been authority in the state of Kansas then for many, many years. And you may be right. Maybe the Supreme Court may decide that under their current standards for interpreting statutes, that Silicon would be overruled. However, as we said here today, it's binding precedent on us, is it not? And we have no ability to reverse or overrule a Kansas Supreme Court case, do we?
Your Honor, I have two responses to that. First, again, we don't believe that the statement upon which the fund is relying is binding precedent. Rather, it's dicta, something that was said in
No, I understand. I'm talking about the case itself right now, because you're saying the case itself was wrongly decided. And I just want to make that clear that we, unless you disagree, that we have no authority to overrule that. Supreme Court certainly does, but we don't.
Sure. Thank you, Your Honor, for the clarification. Again, we're not necessarily arguing that the entire case was wrongly decided. Actually, I believe that the true holding of the case was correct, that the worker does not have to exhaust remedies before impleting the fund. Rather, the worker has an option to proceed against a principal or implead the fund. But second, I do believe, Your Honor, that the court in this case does have the option to essentially, if the court believed that the statement upon which the fund is relying is binding, to overrule that statement. And we cited the Schneider versus City of Lawrence case, which was a 2019 case out of this court, which in kind of a similar setting, interpreting Workers' Compensation Act statute, overruled prior precedent from the Kansas Supreme Court. In that case, a panel of this court noted that the Supreme Court case rewrote the plain language of a revival statute to validate its holding. And again, we believe that's what happened in Silicon Distributing Inc. The statement was made in passing to validate what the court was deciding that day.
Counsel, let me interrupt you. Your time has expired on that. Why don't you take a couple of minutes, if you would, to speak to the issue in the cross appeal, and then we'll hear from the appellee.
Yes, Your Honor, I will. So on the cross appeal, the fund is arguing that it was entitled to its attorney's fees, again, under the same statute, KSA 44532A, subsection B. And the basis for that argument is the language in the statute that says the fund is entitled to recover any amounts paid from the workers' compensation fund. As we set out in our brief, the conclusion of that sentence says any amounts paid from the workers' compensation fund pursuant to this section. Pursuant to this section, what does that mean? Again, this is straightforward, applying the plain language of the statute. Pursuant to this section means as authorized by this statute. Now, what payments are authorized by KSA 44532A? Under subsection A, the payments that the injured worker applies for is an award of compensation benefits, including medical compensation, to which such an injured worker is entitled to be paid for the workers' compensation fund. It's our position that attorney's fees are not included in the authorization under subsection B, any amounts paid pursuant to this section, the KSA 44532A.
Thank you, counsel. I appreciate that. And then you still have your rebuttal time.
Thank you.
Well, let's hear from the appellee.
Thank you, Your Honor. If it please the court and Mr. Van Orsby, as I previously said, I am John Nodgard, and I do represent the Commissioner of Insurance for the state of Kansas in this matter. I think the court has already given an impression that they understand the crux of this case, and that is the appellant is asking this court to look strictly at KSA 44532A and overrule the Silicon Distributing case, as opposed to looking at the interplay between 44503 and 44532A and affirm the ruling as expressed in the Silicon Distributing case. The fund's position is that the Silicon case clearly lays out the interpretation to be given when addressing the facts of this particular case. The purpose of 44503, as originally enacted back in 1927, was to impose liability on a general contractor for the subcontractors for which he employs. The fund was established in 1974, and the enactment of 44532A gave the fund the right to pursue recovery for any amounts that they were required to pay pursuant to 44532A.
Let me stop you right there for a second, counsel.
Certainly.
You mentioned that the fund was created by the legislature in 1974. Is that correct?
That is correct.
What was the purpose behind creating the fund?
The legislature enacted and established the fund to enable an agency who was readily available to pay a worker who was injured on the job as expeditiously as possible.
Is that not the purpose, the general purpose avowed even still today, after all of the amendments, is to pay these injured workers the benefits that they are entitled to?
That is correct, Your Honor. And what you need to differentiate a little bit is that in this case, we have a general contractor, but a lot of times you'll have a single employer who will employ employees and not maintain workers' compensation insurance. And if one of those employees is injured and that employer is insolvent, the employee would have no recourse against anyone for benefits. And that's why the fund was originally created, to set up an agency or a fund that the injured worker could immediately pursue and receive benefits, especially medical, as soon as possible. In this case, you also have a general contractor, and that's what brings in 44503. So
would you agree with me that an injured worker in a scenario such as this, injured worker had an opportunity to pursue a workers' compensation claim against Trademark?
he certainly did. He has the option to pursue his immediate employer, or under 44503, he can pursue the general contractor. And that's his option. And in this particular case, the claimant, who was represented, sought to pursue the immediate employer and then implead the fund, which he did.
If the fund now stands in the place of the employee, the injured worker, why shouldn't you have the ability to pursue the same relief from Trademark as the injured worker?
Well, I think 532A subparagraph B specifically gives the fund the cause of action to pursue the general contractor for any and all amounts that the workers' compensation fund pays to the injured employee.
You could also pursue the subcontractor as well, could you not?
That is correct. And in fact, you could join both of them in litigation. In this particular case, early on, it became quite evident that the immediate employer in this case was not financially able to pay the benefits as required under the Kansas workers' compensation laws. He had no insurance and, again, was financially unable. So that's the typical situation why the fund is involved in these cases. However, again, in this case, we had a general contractor. So we attempted to implead the general contractor, which is not specifically allowed by statute, but we put the general contractor on notice that they were exposed in this case.
Now, implead, you're talking about in the workers' compensation claim that was where the fund was brought in, you tried to bring in Trademark, but that was not permitted.
That is correct. Now, Trademark could have voluntarily come and entered the case as the general contractor, but they chose not to do so. That's one of the issues that I'll address with respect to the attorney fees in our claim in this matter. But
before you get there and leave this subject, is anything that we do in this action affect Trademark's ability, if they so choose, to file a subrogation claim against the direct employer, either Mr. Ballin or his LLC? I recognize they're insolvent today, but they could win the lottery tomorrow. Is there anything that would prohibit Trademark from pursuing a subrogation case for any amounts that they paid reimbursed to the fund?
No, Your Honor. They can pursue. They could pursue Mr. Ballin in this matter or his LLC if they choose to do so.
And then let me ask about, you've heard counsel's argument. It's a good argument that today the Supreme Court is pretty clear that we interpret statutes according to the plain language. However, we're dealing with an act here. When we interpret a statute individually by the plain language, that's one thing, but aren't we also to interpret each provision of an act together and construe them together to try to find the legislative intent?
You're absolutely correct. And there's a whole long line of cases that address that issue, but specifically in the Silicone Distributing case at page 556, the Supreme Court said, in construing statutes, the legislative intent is to be determined from the general consideration of the entire act. And that's exactly what you're saying. And they then went on to say, in determining legislative intent, we are not limited to consideration of the language used in the statute. We may look to the historical background of the enactment, the circumstances attending its passage, the purpose to be accomplished, and the effect the statute may have under various constructions suggested.
But here we don't really need to look at the historical background and what may or may not subjectively entered into the legislature's mind. We only need to look at the act in its entirety, and we find other provisions that explain what is meant by employer under the Workers' Comp Act. Is that correct?
That is correct, and that's exactly what the Supreme Court said when they set up their subparagraphs in that Silicone decision. They specifically addressed the interplay of 44503 and 44532A that we have just discussed, which indicates that if the contractor, under his statutory obligation to ensure that all his subcontractors are financially solvent to pay for injuries, and if he fails to do that, then under 44503, he becomes responsible for payment of those benefits. And that's what the court was addressing there. They then set up that second subparagraph or subsection where they construed 44532A and specifically found at page 561, they say, if the fund is liable as a result of an immediate employer's failure to pay, which is what we have here, it may assert a cause of action against the principal in a separate action under 44532AB. And that principle is defined as laid out in 44503. So essentially, they're carrying out the entire act, and that is they're holding the general contractor responsible for all his subcontractors. Finally, in that regard, I would then suggest to the court that the Silicone Distributing was in fact actually rendered in 1991. So the legislature, if the legislature had disagreed with the interpretation of these statutes as laid out in that case, it's had the opportunity to do so for over 30 years. And this failure to act amounts to a ratification of the interpretation placed upon these statutes by the Supreme Court. Therefore, we're asking the court to affirm this portion of the district court's decision against Trademark. With respect to the issue on attorney fees, we get into 44532 subparagraph B, as we've already discussed, which gives the fund the right to pursue either the immediate employer or the general contractor, the principal, for recovery. And the statute says all amounts paid pursuant to this section. Now, 44532A subparagraph A sets up the procedure for an injured worker to pursue claims against either the employer or the general contractor. And if they're uninsured, then he has the right to implead the fund. Excuse me. The fund then under the statute, has a obligation to defend the claims that are being made. And the insurance commissioner, in order to defend those claims, has to hire legal counsel to defend in the workers' compensation proceeding. The statute, subparagraph B, does not limit the amounts that the fund is entitled to recover to only medical benefits and disability benefits. It says all amounts paid by the fund pursuant to this section. And we read that as all amounts paid by the fund in carrying out the legislative intent to allow the injured worker to pursue his claims against the fund under subparagraph A.
Are there any cases that would support your position on that?
No, Your Honor. This is a case of first impression with respect to the issue on attorney fees.
So this is basically, your argument is inconsistent with the American rule on the payment of attorney's fees.
Well, I don't think it's necessarily inconsistent, because this particular statute says the fund is entitled to recover all amounts paid. And
let's move this over hypothetically to the civil realm. In the civil realm, you can't get attorney's fees unless there's a statute that specifically says, and we know that the legislature knows how to do that. They know how to put in and say, including reasonable attorney fees and expenses. And if that language isn't there, we do not allow attorney's fees in civil cases. So why should we do something different here?
Well, simply because the legislature enacted that statute and used the word all. But
they use all in a lot of statutes that unless they say including, attorney fees are treated differently traditionally, historically in the United States, than other types of costs. It's not even included as cost. So it seems to me there needs to be something specific, but you think that it's just broadly interpreted, therefore, because of that, it should include attorney's fees and expenses.
That is our position, because those are expenses that the commissioner has to incur in order.
Oh, I don't doubt that, but I'm just saying I think the legislature could have, or it still could, if that's the intent, specifically as they do in other statutes, say including reasonable attorney fees and expenses, and that's just not in the statute now.
I agree, it's not in there right now, but
Counsel?
Yes.
Counsel, if the fund has been in place since 1974, why is this issue now being raised for the first time? What appears to be a case of first impression. I assume the fund has paid fees out in the past for or compensation related expenses and has not sought reimbursements of its attorney's fees to defend the fund.
I would take exception to that statement, Your Honor, because I've represented the fund for over 40 years and have on many occasions pursued a employer or a general contractor and sought attorney fees and have recovered attorney fees. Now, a lot of those cases, the defendant basically didn't defend, and so we were able to obtain a judgment. In this particular case, Trademark, being solvent, has chosen to come in and defend the action, and that's why this issue was raised.
Okay, so you're telling me you've raised it in the past, it's just not proceeded to an appellate level case.
That is correct.
Counsel, your time's expired. So if you go ahead and complete, go ahead, Judge. I'm sorry, I didn't mean to interrupt you. For your
no, I think he answered my, I wasn't aware of any other prior cases, so I wanted to clarify that.
Yeah, it has never reached the appellant level. And specifically, I've never even had it raised at the district court level in all the years that I've been representing the fund. So we're simply asking the court to find that we are entitled to recover the attorney fees pursuant to the statute and the language specifically saying all The only other thing I would say, and I raised the issue, is whether the court could find an exception under that Hutchinson case or the Hawkins case, and grant the fund the right to recover attorney fees. Because what happens in this case is Trademark was put on notice that they're exposed. They chose not to come in. And now that they're in, and if they're held responsible, they were able to escape their responsibility for paying attorney fees to defend the action in the first place. So essentially, even if the fund can recover against them, they've saved themselves a substantial amount of money that they would have had to pay for attorney fees.
Thank you, counsel. It's now time for rebuttal. We'll hear from counsel for Trademark.
Yes, Your Honor. May it please the court. I want to begin first with a quick discussion of Silicone Distributing Inc. Again, it's Trademark's position that the language upon which the fund relies and the district court issued its opinion is dicta. It's not binding on this court. And it's our position that the court ought to carefully construe these statutes according to their plain language, consistent with the Supreme Court's directives. And if that's done, it's clear that the cause of action that the fund has is against an uninsured or insufficiently self-insured insolvent employer. The title to the statute says as much: a cause of action against such employers, those that are uninsured and insolvent.
So in your view, that language limits the fund's ability to only pursue some sort of action against an insolvent employer. Is that correct?
That's correct, Your Honor, but
well, let me stop you there for just a second. If that's so, doesn't that turn the fund into the insurer for insolvent companies, employers?
That's not necessarily that's not necessarily the case, Your Honor, because that's the reason why the legislature saw it fit to give the fund a cause of action against such employers in district court, so the fund can proceed to try to recover those funds. But that's clearly what's set out, is that before the fund might become liable for some benefits, there has to be a finding from the ALJ that the employer was uninsured or insolvent.
So that limits the recovery only for the injured worker, only to the fund, and the general contractor escapes liability.
That's not necessarily the case, and that's a good point where I was going to move. Is under KSA 44503, the worker has an option to proceed against the principal. And there's the language that the fund focuses on regarding the substitution language. But the issue is, when does that substitution come into play? When a worker files or serves a claim for compensation against a principal or initiates workers' compensation proceedings against a principal, then and only then do references to the employer within the act get substituted for a principal. That didn't happen in this case, but let's say for a second it did. If we looked under 532A, again, what we're looking at is the fund having a cause of action against an uninsured or insolvent principal, because the worker would have had the opportunity, and Trademark or principal would have had the opportunity to go through the workers' compensation proceeding, and if and when an ALJ found that principal was uninsured and insolvent, then the fund would be impled, and the fund would have a cause of action against the principal because there's this finding. And that's what the statute 44532 sets up, and is clearly reflected in the statute, that the cause of action will be against such employers, or if there's a substitution, such principals, those that are uninsured and insolvent.
You've got 1 minute, counsel.
Okay, I'm going to briefly talk about the fees here. I believe Judge Bruns directly touched on this point. The legislature knows how to include language granting attorney's fees, and in fact, it did so on several occasions within the act, specifically KSA 44510K, which allowed award of attorney's fees and costs and post-judgment awards of medical benefits, KSA 44532 or 512A, and KSA 44536A. In each one of those statutes, the legislature specifically spelled out when attorney's fees were to be granted or allowed. That's not the case in the statute at issue today. So we'd ask that the fund's request for attorney's fees be not be allowed. As for the exception that Mr. Nardgar briefly mentioned, we briefed this in our brief, we'd incorporate those arguments, but the exceptions are very, there's four elements to that exception. The first is that the defendant or the person that they're seeking fees from committed a tort or violated a contractual duty. That didn't happen here. What you didn't hear Ms. Nardgar argue is that Trademark was obligated to come in and defend a workers' compensation proceeding in which it was not named as a party and the worker never sought compensation from it. So it fails at the start on the first category or first element. And then the second element is that the third party litigation, the workers' compensation proceeding, is an actual approximate consequence of the defendant's wrongdoing. That's not the case here. The fund was impled by statute. They had a statutory obligation to come in and defend, but there was no wrongdoing by Trademark that required the fund to participate in the workers' compensation proceeding. So, Your Honors, Trademark would request that the court reverse the judgment of the district court granting summary judgment to the fund on its claim under 44532A subsection B and remand with instructions to enter judgment in Trademark's favor. And it would ask to affirm the district court's denial of the attorney's fees to the workers' compensation fund.
Thank you, counsel, to both of you. This has been a very interesting presentation. We'll, of course, take the issue under advisement and issue a written decision in due course. I can't tell you when that will be, but we'll do our best to keep you advised.